Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. I'm here with Ann Lipton, as we all know, a law professor at Tulane in New Orleans who teaches and researches securities and business law. She holds up the legal end of the podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Well, thanks. How are you doing this week, Ann? Doing pretty well?
Thinking a lot about the election.
Yes, me too. But we missed you last week. You were traveling. You had a conference.
Yeah.
And I think this week, you told me you were grading papers. Is that still right? Or?
No. I've got more conferences coming up. I've got a lot of
Oh, more conferences. All right. So maybe a little more travel. All right. Cool. Let's figure out what we want to talk about today. We will talk about the interesting and somewhat subtle subject of who controls a company or a corporation, and sort of the legal nuance that works there.
And we'll take one more look at director say on pay.
Yes. All right. Let's talk about control. We could spend probably several entire podcasts talking about control. It's a very rich subject, a lot of law in Delaware and other places and so forth. And it's very relevant to folks like me because we want to know who's controlling it and how they're exercising that control. But we really want to focus on some of the legal aspects of it. And it runs through, there's vast swaths of corporate law in Delaware and other places where control is, relevant or probably the central question. And there's some recent developments, too, that kind of advance what it means for an investor or an executive or a director to exercise control over a company. So let's explore that a little bit and sort of, figure out, what some of those advancements kind of mean day to day. But let's begin with some of the grounding, some of the traditional, sort of definition or meaning of control.
Yeah. Well, there are different definitions of control. In general, you're considered a controller or controlling stockholder if you have more than 50% of the voting power of a company. And that can include either a single investor or a group of investors who work together. They'll be joint controllers. That's what we call hard control. You have more than 50% of the vote.
Right. But if you control those votes, you call the shots.
Exactly. But
All
even
right.
without 50% of the voting power, you can have soft control, meaning you're considered a controller if you can be shown to have a combination of voting and managerial power that in practical effect gives you control over board functioning. And control over board functioning can either be shown generally, just sort of how the company runs, or it can be transaction specific, like maybe you're not a controller all the time and for all purposes, but you exercise sufficient control over the board for one particular decision, and you're considered a controller for that transaction only.
Okay.
But the test for soft control depends on all facts and circumstances, so it can be very indeterminate. You look at personal relationships between the putative controller and board members, or bullying even by the putative controller comes up. Bullying, like they call up the directors and say, I'm going to sue you. Right. You can look to whether the putative controller has contractual relationships with the firm or governance rights like blocking rights or the right to designate board members. Even another role in the company, like being a CEO, might contribute to a finding of controller status if it means that person exercises outside influence in the boardroom.
All right. So there's these kind of two aspects. There's really, as you said, and I actually wasn't familiar with the idea of, or at least the terms of art between hard and soft control. Hard means you got the votes, and that would be literal, common, votes associated with common shares, or kind of de facto or practical control without, in fact, having those votes, and we'll call that soft control.
Right.
And that could be situation specific. It could be with respect to one or another aspect of corporate life, as opposed to overall, soft control over the whole thing.
Yeah, usually that's how it's analyzed. Either you have control over the company generally, some way, or given the particular circumstances, you exercised control in one particular transaction.
All right. Now, why do we care? Why is this important?
Yeah. So a finding of control has several distinct legal consequences. And just to be clear, this is only relevant if there's a shareholder lawsuit. No lawsuit, no problem. But often shareholders sue, and they argue that some kind of transaction with the controller was unfair to the other shareholders. And in that context, a finding of control matters for at least 3 reasons. So first, a controlling stockholder owes fiduciary duties to the minority shareholders. So the controller has to be fair in its dealings with the minority and the corporation as a whole. It can't behave like an arm's length counterparty. And that's different from an ordinary stockholder. So like imagine I have a tiny amount of IBM stock. I don't owe any duties to IBM. And if I form a contract with IBM, I don't have any responsibility to make sure the contract is fair to IBM. I can look out solely for my own interests. But a controlling stockholder is different. They're a fiduciary, and they do have to make sure their dealings with the controlled company are fair. So that's the first legal consequence that we get from being a controller. The second is the issue of cleansing. And we've talked about this a few times before, and I'll say it again. If any fiduciary engages in a conflicted transaction with the company, a director, an officer, or a controlling shareholder, any fiduciary, if they engage in that transaction, they have to make sure the transaction is fair. And if someone sues, that's a really onerous inquiry for the court. It requires discovery and experts, and there's a whole trial. So courts have come up with these cleansing mechanisms. If the corporation takes the right procedural steps at the outset to protect minority stockholders, then a reviewing court will just defer to the board and won't let shareholders sue. If the fiduciary is a director or an officer, that cleansing mechanism is either the unconflicted board members have to approve it or the disinterested shareholders have to approve it. But if the fiduciary is a controlling stockholder, then you need both mechanisms, a shareholder vote and unconflicted board
and a proper board.
Yeah, exactly.
Actually,
so
the order would be the board vote and then the shareholder vote.
And then the shareholder vote.
You need both.
Right, and that's much more onerous. So cleansing a transaction with someone who is deemed to be a controller is actually very, procedurally difficult, and that's the second issue.
Right.
And the
well,
third
procedurally
issue,
difficult because you need
both.
Put the vote together. I mean, it's one thing to put like a board vote together. That happens pretty quickly, but like.
Right.
A shareholder vote, not only do you have to kind of schedule, but you got to go round up the shareholders and get them to vote.
Yeah, and also if there aren't a lot of unconflicted directors, then maybe even the board vote is difficult. So sometimes we have situations where the issue is actually not at the stockholder vote level; it's at the board level. But that's the second issue.
Go ahead. Sure.
And the third issue of control, which doesn't come up that often, but does come up sometimes, and it has to do with the value of control, and in particular the procedural barriers to shareholder lawsuits. So. Control rights are financially valuable. I mean, that's why if someone buys the company, they pay a premium for the stock.
A control premium, exactly.
Right, exactly. A block of shares that aggregates a lot of voting power is more valuable than the shares individually, where each individual vote has little influence. And sometimes a board functionally hands over some kind of governance power to someone else, usually an existing investor. Maybe the board forms a contract with that investor to just give them more governance rights, which they can do more easily now because Delaware just amended its law to allow these shareholders.
They just allowed certain counterparty shareholders to basically exert control, as we say.
Right. It as just from a contractual handing it to them. Or in a recent case involving Hertz, the board conducted a share buyback. And they bought up a lot of the publicly traded shares. And the effect was to increase the proportionate stake of an existing investor. So that investor went from being a large block holder to having hard control, more than 50%.
Oh.
And so sometimes you have these transactions where control rights are functionally transferred to somebody. And a shareholder might challenge these transactions on the ground that the board conferred a benefit on someone, maybe an insider, maybe an activist selling
or some shareholders, or a friendly shareholder in the face of an activist. Sure,
exactly. So a shareholder might sue and say, "Board, you handed this valuable control to somebody without getting anything in exchange." And when that happens, when a shareholder brings that lawsuit, there's an important procedural question. Is that a direct claim by the shareholder, or is it a derivative claim?
Oh, sure.
Right.
So, and that's a matter of whether that shareholder was hurt, or whether it was all shareholders were hurt, right?
Or whether it was or whether they're hurt because the company was hurt. So derivative claims are brought by shareholders who allege the board inflicted harm on the corporate body. Sure. So shareholders were harmed derivatively. And direct claims are brought when shareholders allege the board hurt the individual shareholders. And the difference matters a lot because derivative claims are much harder to bring. There are certain procedural requirements, and I'll come back to what those are later. But for now, it's just harder to bring a derivative claim. Direct claims are easier. And now there's this new case law suggesting that at least some of the time, if governance rights are transferred to someone, especially if someone previously not a controller now becomes one, those claims can be brought directly because the theory is it doesn't hurt the company at all. It just takes away governance rights that shareholders previously had. Okay. So that's the third legal issue that comes up when we're talking about control. Is this a right that was taken from some shareholders and distributed to others in a way that allows shareholders to bring their claims procedurally as direct claims, which is just much easier to do?
Right. Then it becomes, I mean, I'm not going to say a contract case, but then it's between the shareholder and the company where the shareholder is alleging the harm.
Yeah. And the shareholders are like, they lost governance rights. The company wasn't harmed at all. The company's fine. It just has a new person who's in charge of it. But the shareholders are alleging, you took my governance rights away.
Right. And this is what I think they're worth, and this is what I think the remedy should be, or whatever. All right. Mm-hmm. Wow. Okay. So there's those three aspects of it. We started alluding to some of the recent developments. Let's be a little more specific about what those look like.
Yeah, so there are these increasing use of shareholder agreements that allocate specific governance rights to particular investors. And now, as we did in a prior show, Delaware just changed the law to make sure that those contracts are valid. So we
that was in response to the Moelis case.
Exactly.
Okay, go ahead.
And we also have these large private companies, and they tend to issue preferred stock with different kinds of control rights to different investors. And companies are now increasingly going public with very complicated multi-class stock structures. Right, yeah. Which means not always obvious.
It's maddening.
And it's not always obvious who has hard control, who has 50% control. Because investors have all these idiosyncratic governance rights and different kinds of relationships to the board. So this fuzzier, malleable test for soft control becomes more important. So it's harder to tell when there's control. But then that's the business side. But on the legal side, there have also been developments. As I said, if you want to cleanse a conflicted transaction, it matters a lot whether you're a controller or not a controller. It's harder to cleanse that transaction if you're a controller. Right. This different cleansing mechanism, that's relatively new. The case law really only fully developed on that in the last 10 years. Okay. So let's say you're a plaintiff. There's a conflicted transaction. You want to sue over it. Very often, the transaction only uses one cleansing mechanism, only a shareholder vote or only independent board approval, which means you as an enterprising plaintiff, you're very incentivized to say, hey, I think this person is a controller, so it wasn't cleansed. That's why you see claims alleging Elon Musk is a controller of Tesla with 22% of the shares or the votes. There's a case pending now before the Delaware Supreme Court, just had oral argument, and at least as of this recording, the decision hasn't come out yet.
What case was that?
Oracle. It alleges that Larry Ellison of Oracle was a controller with only about 28% of the vote. Oracle bought Ellison's company NetSuite, and the vice chancellor concluded that Ellison was not a controlling shareholder of Oracle with 28% of the vote. Therefore, there only needed independent board committee approval to get court deference. So, of course,
rather than a shareholder vote over it.
Exactly. Right. Okay. So the plaintiffs are arguing Ellison was a controller with only 28%. Therefore, Oracle needed shareholder approval in addition to board approval. And since it didn't get that, the transaction should have been analyzed for fairness. So we see a lot of these cases that try to push the envelope for how control is defined. Meanwhile, if the transaction is kind of hinky, then a court of equity, I think, Delaware, is incentivized to say, this could be a controller, because that's the only way they can get at these, sort of transactions that look a little dubious. And so you end up with some decisions that suggest a rather capacious definition of control. And all that are relatively recent developments that come partially from these complex governance structures, and partially from the fact that the law changed to make the legal consequences of control or not control really different.
Got it. All right. So we have at least those couple cases, and then there's others. There
are lots of others.
As you and I kind of noodled through this to plan it a little bit, there's many directions this can go. Mm-hmm. Do you have any expectation about how some of these cases are going to work out? You said one just got argued, but we're not sure it's going to happen. So give us a little perspective on that.
I don't think the current situation is really sustainable. There's just too much uncertainty regarding who counts as the controller, and that makes it hard for transaction planners. It makes it hard for litigants. And these procedural protections required for controllers, they're not costless. I mean, it's expensive to set up a committee process and then get a shareholder vote. It takes lawyers. It takes time. Smaller transactions may not be worth it. Vice Chancellor Laster just came out with an opinion where he sort of said in passing that the company argued that the MFW, that's what it's called, that this process was so expensive it wasn't worth it, and he believed it. So I don't want to overstate that, because it only matters if someone pursues, and claims over smaller transactions aren't going to be brought directly. They're going to be brought derivatively. If the company is still generally intact and just formed a contract with a putative controller, like Tesla buys Solar City or Oracle buys Larry Ellison's company NetSuite, those lawsuits are brought derivatively. And as I said, derivative actions are hard to bring. Among other things, the plaintiff has to show that at the time they filed the complaint, the board had a majority of directors who were beholden to the controller in some way. That's an additional requirement. Cases brought derivatively, on top of the whole cleansing procedure, that the board was majority beholden to the putative controller. So that kind of forestalls shareholders from bringing lawsuits over really minor things. But still, the current system, it's expensive and it's a headache, and we're getting these rumblings, and it's one of the trends of creating dissatisfaction with Delaware as a place to incorporate. This is why Gregory Maffei is trying to move TripAdvisor out of Delaware to Nevada, where the standards are less strict.
Because he's a deal maker, and he's a controller, and he wants less. And it's funny because I've thought a little bit about how this. When we get shareholder votes and stuff, and I would also speculate that one of the reasons that, and I've seen this all the time, that boards don't want to hold a vote to cleanse a transaction is because they don't want to take the risk they might lose.
Oh yeah, I'm sure they don't want to take a list, but I think there also really is a cost to it as well.
Clearly it takes another 12 weeks. You add some time. There's some legal fees.
And I think people who are controllers of companies tend to have a mindset. It's their company. They can do
what
they want. I think they just emotionally resent. They resent the restrictions. So there are these calls to change the law. We've heard it from academics. We've heard it from members of the bar. And I don't think the Delaware Supreme Court is going to change this cleansing standards because it just reaffirmed them. Yeah. But the legislature could step in and set new standards. But what I think the Delaware Supreme Court certainly could do is try to narrow the concept of who counts as a controller in the first place. And I think we're already seeing hints of this. For example, the question whether Elon Musk controls Tesla with 22% has come up a couple of times. Yeah. It came up in his pay package case. I actually don't think that makes the legal difference at the end of that case. But it also came up in the case about Tesla's buyout of Solar City. And the court didn't decide whether he was a controller there. It managed to avoid that question. But on appeal, the Delaware Supreme Court offered hints that it might limit the definition of control to investors who can elect or remove directors, approve transactions, or block transactions.
Oh, that is pretty limiting.
So that we would really limit it. And so now there's this Oracle case pending where there are actually a lot of different arguments, but one of them is Larry Ellison was a controlling shareholder with 28% of the vote, and that's another opportunity for the Delaware Supreme Court to start offering more guidance on this.
Interesting. One reason I like discussing this, the idea of control, is you've written extensive, more than blog posts. You've written a bunch of published literature.
I've written 2 articles on this. But my big issue with all of this, and I said at the beginning, when we ask about control for different reasons, right? We ask to determine if someone has fiduciary duties. We ask to determine if they need this special cleansing mechanism. And we ask, and I think we'll ask a lot more in the future, to determine if control rights have been taken from the stockholders and transferred to someone else. But even though those are really different things, we actually have this one test for control, exercising influence at the board level, considering all these different factors. And my view is that we actually should have different tests depending on why we're asking the question. So, for example, the question whether someone has control over the board's functioning is most important if we're trying to determine if that someone has fiduciary duties to the company. Like, again, the company decides to buy an asset from someone who is 1% of the stock. That's very different than the company buying an asset from someone who is 45% of the stock.
Who's almost near hard control.
Exactly. In that latter case, we suspect the 45% stockholder might have had influence over the board's ability to bargain. And if the shareholder does have that kind of influence, the shareholder could have induced the board to overpay for the asset. So we impose fiduciary duties on that shareholder. You can't sell your asset to the company unless the deal is fair. But think of a situation like Ellison and Oracle. Shareholders claim Ellison's a controlling shareholder, fine. But they aren't saying that because they want to know if he has fiduciary duties. He definitely has fiduciary duties. He's on the Oracle board. He's the chief technology officer. There's no question he has fiduciary duties. In the Oracle situation, what we really want to know is, can his deals with the company be cleansed by board approval alone? Or do they need the extra protection
and
of
the shareholder vote? Right.
If that's the question, then I think we need to go back to asking, well, why do we have those protections? And the reason is, controlling shareholders are scary. They're scary because they can retaliate against board members or even minority shareholders who go against their wishes. They can remove
abuse
directors.
the assets or do all sorts of weird stuff.
Exactly. They can remove directors. They can refuse to pay dividends. And if they do retaliate, minority shareholders can't remove them because they're entrenched. So it's not like a director saying, I'm annoyed with the shareholders, I'll punish them. If an ordinary director does that, you vote them out. But when a controller does that, there's nothing you can do. So the theory goes, minority shareholders or independent board members might be afraid of the controller, and the dual protection cleansing is supposed to sort of help bolster their courage. They back each other up. So my theory is, if we want to know whether we should use these extra cleansing mechanisms, we should ask about that. Is this person capable of retaliating? And is this person entrenched? In other words, I think we're using one test to answer different questions, and I think we should use different tests for different questions.
So you're looking for a much more nuanced, as we said when we introduced this, consideration of the responses to control.
Exactly. But then,
and it depends on whether it's hard or soft, and it depends on the situation, depends on whether it's
why we're asking the question and what the legal implications of the question are. But I'm an academic. I don't have to litigate these things, and we academics love nothing more than inventing new tests.
That's why we value that. That's why we love you. So anyway, all right, we have to take a break. There's a lot to think about here, and we got other stuff to talk about. So let's do that, and we'll come back a little bit to talk about director say on pay here at Shareholder Primacy.
This is the Free Flow Media Podcast Network, where we cover the who of the business news, because investing isn't a what, it's a who. Check out our other podcast, Business Pants, for fact-based snark covering companies and executives, and the Proxy Countdown, the only podcast that treats company meetings like sporting events. Find them on iTunes, Spotify, or wherever you get your podcasts. Back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin. And we are going to talk about director say on pay, which is kind of new, I guess, right? What do you...
Very new. Very new. It had its origins in a little case that we've heard about here, but then, it's a cousin of executive say on pay.
Right. So you mean something other than director cleansing. What do you mean when you say director say on pay?
So director say on pay is... pertains to the idea that shareholders should approve what the amount and structure of what directors get paid. Mm-hmm. Most directors in the U.S. are compensated. The other exceptions are directors that are executives of companies where they sit. Though clearly directors are executive of companies that serve on other boards. They get paid for service on the other board. And occasionally... you'll have an investor, a portfolio manager that serves on a company board, and they decline the pay because they're getting paid by the portfolio manager. But 90+%, a huge number of independent directors, they're in it in part for the money. So that's their pay. And we talked for a second ago about executive say on pay, and right now shareholders, and this is an SEC requirement, shareholders get to vote on, as we read in proxy statements, on an advisory basis on whether they kind of like or don't like what the executives are getting paid. And that's really just sort of a test of sentiment. Mm-hmm. It can reflect sort of how shareholders feel about the companies, what they're paying the executives. It can also just reflect what the shareholders feel about the company. But that's strictly advisory. The companies can blow it off. They can sort of pay attention. Most of large companies take it sort of seriously and try to understand if they're getting really, really adverse executive say on pay results. They'll they'll try to listen to shareholders and see if they can respond in some way. But it legally it has no force. It is no impact. So yeah.
Okay. And so what are you thinking in terms of directors?
Directors say on pay. Well, I have, and this is me, I've long thought about kind of how shareholders relate to directors and how they can have better influence over the directors that they elect. And, in the U.S., almost all directors set their own pay in terms of structure and amount without really any kind of oversight from shareholders, other than shareholders' ability to kick them out of office and defeat them in an election. But there's no direct impact influence that shareholders have over the directors that they elect in terms of what they're getting paid.
Okay.
So, and I've kind of thought about that a lot. I wrote about it some and so forth. And then when the Detroit case, the Tesla director pay case, was the preliminary settlement was announced. We talked about this in an earlier show. The Tesla agreed to subject its directors to a binding vote of its shareholders approving what Tesla directors would get paid by the company. And I saw that and I got very excited. So, wow, this could really be cool. And I kind of wondered, why we didn't see that before. What's been going on. I looked a little bit into Delaware law about how directors can pay themselves, and I think they can. I mean, about that.
The directors can set their own compensation, and just going back to the previous segment, it's considered a conflicted transaction. I mean, if you set your own pay, that's a conflict.
Right.
So it has to be cleansed by a shareholder vote, but if it's not cleansed, they still get the pay. It's just that if someone sues, it's analyzed for fairness.
Right. And there have been relatively few lawsuits over.
Yeah, there have been a couple. There have been a couple, but the one that you just talked about at Tesla was one.
Right. Yeah, Tesla was a biggie, and importantly, that was settled. So there was no, at least as far as we know now, there's been no new law created around that case, at least yet. Chancellor McCormick has yet to approve the settlement, but we'll sort of see. Anyway, we can go back and re-listen to that segment. We can hear about some of the nuance there. But the important thing here is that after that experience, I wondered, how could this apply at other places? Are there other companies that could sort of benefit from shareholder oversight of director pay in this way? And I decided to try it out. So what I did is I identified a bunch of companies, and none of them were, as bad as Tesla for sure, but they all pay their directors well, and conceived of sort of this doubly binding idea. So in contrast to the executive say-on pay situation, where it's strictly advisory and it's this kind of shareholder vote and so forth, I, at these companies, drafted a bylaw amendment. So it wasn't just a resolution where we sort of think that the company maybe should think about considering. Yeah, this is right. If shareholders approve this, the bylaws would get rewritten to require the shareholder vote. Okay, and it was easy. The bylaw amendment was 2 sentences. The most company bylaws, a few don't actually provide for directors to pay themselves, but if they do, it was 1 sentence. Directors can pay themselves, whatever form they can reimburse for expenses or whatever. But it was pretty easy. In contrast to other parts of bylaws I read, it was pretty straightforward. The other thing is the vote was, as we say, binding. This was not some sort of advisory vote. This wasn't going to be one where we're just kind of taking the shareholders' temperature about what we think. This is if the shareholders decline to approve or reject the director pay, they don't get paid. And that's what we had in mind for Tesla, or with the parties that the Tesla case had in mind for themselves, you got to approve it. So
what's the theory directors work for free, or do they come back with a new pay package that's
That's
revised?
a good question. I don't know. If they reject it, maybe directors have to work for. Maybe they'll quit. I don't know. Presumably, they're in it. The independent directors are in it sort of for the money.
Yeah, prestige, I assume.
And the credential. Yeah, put it on. But the expectation would be that if in some way, and look, the likelihood of there being rejected is pretty low. The incidence of successful executive say pay is quite high.
Yeah. Interestingly, in Oracle,
yes,
shareholders rejected Larry Ellison's pay, and the fact that they kept it in place was one of the factors that was used to argue that he had control.
Exactly. But again, because it was non-binding, and they basically said, shareholders pound sand. We know you rejected the pay, but I remember that vote. So anyway, so the idea would be that it would be this the binding vote, as we said, and I work with a friend of mine. Listeners here probably know the name John Chevedden. He's this veteran, experienced governance proposer. And I was talking about it with him. He said, "That's a really cool idea, Mike. Let's see what happens." So he and I identified about 13 of his portfolio companies where we should propose this. And I'd never written a shareholder proposal before. Under 14A8, as we say, under the SEC's rules for allowing this kind of thing. So it was quite a new experience to me. John's done it, dozens and dozens and dozens of times for the last about 20 or 30 years. He's done it plenty. But this was all very new to me. So we identified 13 companies, wrote a proposal, and the proposal was a bylaw amendment for this binding vote where it would, be approved. We submitted them at all 13 companies. There were many companies, 8 of them requested from the SEC no action relief, which was kind of interesting. I had never seen that happen before, at least personally, myself. There were 2 bases that the companies asked for no action relief. The first was that the shareholder proposal potentially could cause them to violate Delaware law. And that was because when we structured the bylaw amendment, we were going to do it in a way where directors were not able to vote their own shares. Director shareholders were not able to vote their own shares on the proposal. That was actually written into the Tesla director, the Detroit settlement, that Elon Musk and Kimball Musk and any directors and so forth would not be able to vote for their own pay. And it made perfectly good sense to us.
Of course.
But the companies argued that you can't disenfranchise those shareholders. And we tried to argue, but there's other places. We went back and forth. And the companies got these letters from local Delaware councils saying how these 10-page letters, and several of the companies got the same letter from the same company. So that was good business if they could get it. Those firms. Anyway, so we got the no action request. We wrote our rebuttal. And then
I'm just trying to, I'd love to see those letters because I'm trying to, I could see you can't say they don't vote for their shares, but you could certainly set a standard that says it requires a majority of the disinterested. That's so weird. But
yes, you absolutely could. The idea of share owning directors not being able to vote their shares was, I think, an interesting and useful attribute, but it was clearly wasn't essential. So after, out of the 8, I think 6 no action requests were eventually granted on that basis. We said we're not making that mistake again if we go back and do this. We just take that part out,
right?
And not require those directors to vote not vote their shares. And then 5 of the companies and then 2 of the companies sought no action relief based on some argument of micromanagement. It's ordinary business.
Ordinary business, yeah.
Where they said, this is the responsibility of the board to set pay and so on and so forth. And that was a little harder for us to try to get our heads around.
It's not ordinary business.
Yeah, I would think not. But again, try telling that to the SEC at this point. So, so those five of the companies did not seek no action relief. So we went and wrote exempt solicitation arguments, kind of responding to the company's response. So again, this is all new to me. So they put our proposal in the proxy with our 500-word limit. Fortunately, we were able to sort of fit in that because the bylaw amendment was pretty tiny. And then they wrote their response, and then we wrote an exempt solicitation argument, kind of responding to what the company put in their proxy and so forth. So that was really cool. So there were 5 companies where it got voted on.
Okay, and
it didn't go very far. The average amount of support from shareholders for this was like about 2%.
Oh no!
It was really low. It was very disappointing. And John consoled me. He said, this happens the first time and so forth. And I talked to some. We had reached out to some shareholders to try to get some feedback about it, and some shareholders. I was talking to some of the big indexers and the companies we'd know, where they said, "Yeah, it's an interesting idea." I did talk to one person who said, "No, this is a bad idea." I said, "Why?" They said, "We have so much to vote on. This is not a." And I'm saying, don't you want to this kind of be able to exert this kind of authority over directors? And it didn't get really. It wasn't a very fruitful discussion. I will say that.
Sometimes these things, it's true. There are a lot of types of proposals that don't get a lot of support at first, and it takes time to persuade shareholders that it's something they should vote for. Exactly.
And part of my problem is I'm stubborn. And I really like the idea of a binding vote based on a bylaw amendment. I'm not satisfied with the idea of just sort of this precatory sense of the, this is, because again, we're not talking about executives. We're talking about the directors that we elect. Shareholders, activists elect. And I think we should be able, and the only leverage we have over these folks is whether we vote them out of office. And for that to really happen, you need a proxy contest, because the majority vote standard just doesn't really work. There's so many zombie directors, so many directors that very few. Yeah. So that kind of so we'll sort of see what happens. I've talked to John a little bit about 2025. We may kind of submit some proposals that are a little less, I suppose, less threatening. Yeah. But we'll see how it goes.
Yeah, one of the interesting things about bylaws is it's really, I'll just say, directors have the power to pass bylaws and shareholders have the power to pass bylaws. And at least in Delaware, there's no obvious reason why a board can't just take, you could pass the bylaw and they could get rid of it.
Oh, right. We have that fear.
The only limit literally in Delaware law that I'm aware of is that if you passed a bylaw about the voting standard for to elect directors, if you made it majority, but otherwise, but under the MBCA, if it's a Model Business Corporation Act state, they have a provision that shareholders can pass bylaws and say, and directors can't touch it.
Right, but in this instance, to the extent that I was able to learn anything about it, we had this fear that if somehow magically, and all the companies we looked at had a majority of outstanding shares to approve bylaw amendments. Yeah. So shareholders were, clearly able to propose bylaw amendments, and it wasn't a supermajority standard. And we had this fear that if by some odds shareholders approve one of these, can't the company just go back and just say, forget it? We're gonna change it the next week.
They may not like it, but there's that happened. It was a separate chair and CEO happened at Bank of America. The shareholders voted to separate the roles, and Bank of America just put them back.
They just said, forget it. It's all right. So we'll see what happens next year. But that was my journey through the shareholder 14A shareholder proposal process with this novel idea on director say on pay. Okay. And stay tuned. We'll see if we do it again next year. I don't know. There's a lot of other things to think about. So maybe we will. Anyway. Okay. So I think how about that?
All right. Well, let's wrap up there, and we'll cover more next time.
Yes, I think we can. It's been terrific talking about all this, Ann. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situation. Ann is, of course, the Michael M. Fleischman Professor in Business Law and Entrepreneurship at Tulane Law School and an affiliate of Tulane's Murphy Institute. You can find me, Mike, at theactivistinvestor.com and find Ann at law.tulane.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening, and we will talk again soon.